This is the fourth of four ProfDale property videos dealing with adverse possession. In this video, we're going to wind up adverse possession by talking about three topics. First, about tacking of successive adverse possessors. That's a situation in which we have more than one adverse possessor, and the question becomes, can we add their time periods together to make the necessary time for adverse possession to operate? Second, we're going to talk a little about constructive adverse possession. That's a situation in which the adverse possessor can actually acquire more land than they possess. Finally, we'll spend a few minutes talking about adverse possession of personal property. To begin with tacking, let's imagine that we have a 10-year statute of limitations. The blue line represents the passage of time starting from today. And let's assume that an adverse possessor moves on the land and stays for 5 years. That adverse possessor moves off, and immediately a new adverse possessor moves on and stays for 6 more years. Neither one of them has been there for the required 10-year period, but if we could add the two periods together, we'd have 11 years, and that would mean that adverse possessor number 2 would become the owner of the land. So the question is, can we add their time periods together? Well, we can if we follow the principle called tacking. What tacking says is we can add the two time periods if there is privity between the two adverse possessors. Now, what do we mean by privity? Well, what we mean is a purported transfer of the land from the first adverse possessor to the second. I say purported because obviously it isn't an actual transfer of title, because adverse possessor number 1 doesn't have title yet. But nevertheless, privity is a purported transfer. What form might that take? How can that privity be established? Well, there are a number of ways. First, there could be a deed from the first adverse possessor to the second. Now, you might be thinking, wait a minute, that's not possible. The first adverse possessor doesn't have title. How can he give a deed to the second one? But don't worry about that at all, because anybody can give a deed to anybody else. You don't have to have title in order to give someone else a deed of the property that you're wanting to transfer. You can have a purported transfer even though you don't have title. Second, it could be a will. Adverse possessor number 1 might die and leave the property to adverse possessor number 2. Third, it could be heirship, where adverse possessor number 1 dies without a will and adverse possessor number 2 is the heir of adverse possessor number 1. Finally, it could even be an oral transfer of the land. Now, of course, a real oral transfer of land isn't permitted. The statute of frauds says that transfers of title have to be in writing. But adverse possessor number 1 doesn't have title. And we're not looking for an actual transfer of title, remember, but only a purported one. And therefore, an oral transfer is sufficient. In effect, adverse possessor 1 is saying to adverse possessor number 2, all this that I don't own yet is now yours. Now, the concept that you can have tacking by virtue of an oral transfer is extremely important in a boundary shifting situation such as the one we have up on the screen. Let's suppose that A and B live side by side, and A builds a fence that encroaches on B's property. It's a few feet over onto B's land. The fence is represented by the dashed line that you see there. Once the fence is built, A occupies that strip between A and B's property and does so for 6 years, and then A sells his lot to A2. The legal description in the deed by which A sells his property will probably just be taken from the deed by which A acquired the property, or the title insurance policy that A received when A bought the property, and therefore it'll be identical to the legal description that A originally acquired. And what that means is that the legal description won't include the strip that encroaches over onto B's property. So A2 buys the property from B with that legal description in A2's deed, and then A2 stays on the property for another 5 years, and the question becomes, does A2 own the strip of land? Well, the answer is that you can't find privity by virtue of the written deed because it doesn't include the strip of land, but in all probability, the court will find privity by virtue of an oral transfer. That is, when A sold to A2, A probably took A2 around the property, pointed out the boundary over to the fence, and said, look, this is part of what I'm selling you. And from that evidence, the court will probably have no difficulty finding the necessary privity in order for A2 to acquire title to the strip of land. Now let's compare that with a slightly different factual pattern. It looks similar, but it's not a tacking issue at all. Let's assume that A builds a fence that encroaches on B's lot, and then 11 years later, after the statute of limitations for adverse possession has run, A sells his lot to A2, once again using the same legal description that was used in A's prior deed. Now the question is, does A2 get the strip of land? Well, you see, the difference is that in this situation, A has actually acquired title to the strip. He's lived out the full adverse possession period and is the owner of the disputed strip. Yet, when A sells the lot to A2, in all probability, he'll use that old legal description that won't include the strip. So does A2 own the strip of land? Well, technically, the answer ought to be no. The technical answer is that that strip of land simply hasn't been transferred. An oral transfer won't count because A is actually the owner of the strip of land and would need to be transferring title to it. So there's a real problem here because the technical answer leaves A with title to the strip of land and neither parcel on either side. It's a sort of nonsensical result, but it's the strict application of the statute of frauds that leads us there. So courts struggle with this situation. They want to give the strip to A2, but it's difficult to find a rationale for doing so, and the courts often simply fuzz up the issue, or they make the mistake of calling this a tacking problem when it isn't a tacking problem at all, because A has already acquired title to the strip before transferring his lot to A2. Now we want to shift to a slightly different adverse possession issue, and that is a transfer not by the adverse possessor, but by the true owner. Once again, let's assume we have a 10-year adverse possession statute. Suppose the adverse possessor moves on the land, and 5 years later, the true owner sells the land to a new owner. The question is, does the adverse possessor have to start all over again with the new true owner? And the answer is no. The adverse possessor doesn't need to start over again. This is sometimes called inverse tacking. What it means is that we don't require a restart of the adverse possession when the true owner of the land changes. In fact, it's just one more example of the principle we talked about in a previous video, which says that nothing the true owner can do with title to the land after the adverse possessor has moved on the land will have any effect on the adverse possessor's acquisition of title. Now time for a few words about constructive adverse possession. Normally, an adverse possessor only gets the land that he or she actually possesses. Remember, actual is one of the 5 elements of adverse possession. But it's possible under special circumstances that the adverse possessor might get more land than the adverse possessor actually possessed. Let's take a look at how that might happen. Here's an 80-acre tract of land, and up in the northwest corner there's a house and a lawn surrounding the house, maybe even a fence, about 1 acre of land. An adverse possessor moves into the house, stays there for the required time period, but never goes out on the other 79 acres or does anything involving them. So the question becomes whether the adverse possessor only gets the 1 acre surrounding the house that they actually possessed, or whether they get the full 80-acre parcel. The answer is they can get the full 80 acres if the elements of constructive adverse possession are present. So what does constructive adverse possession require? First of all, The whole 80-acre parcel must be a single parcel in the public records. It can't be two different lots. Second, the adverse possessor's got to have color of title to the entire parcel. Remember color of title? We talked about it before. It means that the adverse possessor has a piece of paper that looks like it conveys title to the 80-acre tract to the adverse possessor. Now, obviously it doesn't, or they wouldn't need adverse possession. It isn't a valid piece of paper. It might be a forged deed, or a deed that was never delivered, or a tax deed where there was some defect in the tax sale procedure. But the point is, it looks like it conveys title to the full 80 acres to the adverse possessor. The third requirement is that the adverse possessor must actually possess part of the land. So if those three elements are present, the adverse possessor can get the full estate even though they only actually possess part of it. Now, you might say, is there any limit on how far that can go? What if the adverse possessor occupied 1 acre and wants to transfer or acquire title to 1,000 acres? Should there be a limitation? And the courts have occasionally speculated on that, although there's no solid authority on it. But there is a feeling that somehow there ought to be some reasonable relationship between the amount the adverse possessor actually possessed and the amount they get. Now, there's one last little element here. I don't have any case law at all on it, but what if you're in a state where the law requires an adverse possessor to improve the property, or to cultivate it, or to enclose it? There aren't very many states like that, but there are a few. Could the adverse possessor still get more than he or she possesses? Or would we have to have proof that the adverse possessor improved, cultivated, or enclosed the full 80 acres? I don't know the answer, but I think it's an interesting question. So that completes our coverage of adverse possession of real estate. Now we're going to take a brief look at adverse possession of personal property. When we think about the differences between adverse possession of real estate and adverse possession of personal property, a couple of obvious things stand out. First, the statute of limitations for personal property is usually quite a lot shorter, often in the range of 3 to 5 years, occasionally as short as 2 years. So that means that an adverse possessor might succeed in acquiring title much more quickly than with real estate. On the other hand, it is much less likely that adverse possession of personal property will be open and notorious. Why? Because personal property is movable, and therefore it's easy to hide, while real property is out there where anyone can see it if they get close enough. It's really impossible to hide real property. So, if a court uses standard adverse possession doctrine, the thief, or someone who takes personal property and becomes an adverse possessor, will usually conceal the stolen article. That means that the adverse possession won't be open and notorious, and in turn, that would mean that the thief would never acquire title to the personal property. Now, we might think to ourselves, a different rule could achieve a better balance between the true owner and the thief, a rule that wouldn't, in effect, totally exclude the adverse possessor. So there are a couple of alternatives that courts have suggested for adverse possession of personal property. By the way, some courts do follow the standard doctrine, but that makes it almost impossible for a thief to acquire title by adverse possession. What are the alternatives? Instead of open and notorious, one possibility is to say that the statute of limitations starts when the article is discovered by the true owner. That assumes that the true owner is making a reasonable effort to search for the article, or in other words, is carrying out due diligence. The New Jersey court adopted this in a case involving artwork by the famous artist Georgia O'Keeffe. They said that if the true owner is making a reasonable effort to find the article, then the statute won't begin running until the true owner discovers where the article is. That at least gives the adverse possessor a chance of acquiring title, but certainly enhances the situation from the true owner's point of view quite a bit. A second possibility that a couple of courts have suggested is to say that the statute of limitations starts when the true owner makes a demand for return of the article. Now that's even more favorable to the true owner than the New Jersey rule we talked about a minute ago, because now the true owner not only has to find it, but has to demand its return before the statute of limitations will begin to run. That concludes this fourth of 4 videos on adverse possession, but you'll find ProfDale property videos on other topics in the property course on my YouTube channel. If you have questions or comments, send an email to profdale01@gmail.com. Thanks for watching.